Good morning, everybody, or good afternoon, wherever you are on the globe. We have folks participating from a multitude of states and countries on today's webinar, which is distressed cannabis businesses. I can say firsthand in dealing with my clients, a lot of them are feeling the pain points of macroeconomic factors that they just can't control. And then there are a multitude of other issues that are making it really difficult to survive and thrive as cannabis businesses because of the existing federal conflict. We're not going to go through the pleasantries of navigating why cannabis remains federally illegal or those basic issues. This is really tailored to navigating how to act as a distressed cannabis business, how to deal with your debt, how to potentially deal with vulture investors, and then, of course, examining your options in the event of the worst case scenario, which is typically bankruptcy, receivership, assignment for the benefit of your creditors, or UCC defaults, right? State liens, state law liens that go bad that allow a creditor to foreclose on your most meaningful assets. That's what we're going to talk about today. We got a slew of audience questions before the webinar, and I've kind of distilled those down into the ones I think are most relevant. But please, 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 as the webinar proceeds, do ask questions and we will consider them. I'll get them through a chat box via GoToWebinar, and I will float them to our esteemed panelists. So without further ado, today we have Griffen Thorne out of our Los Angeles office, Vincent Sliwoski from our Portland office, and Ethan Minkin joining us from our Phoenix, Arizona office. They each bring, I think, a different view to this particular issue based on their work and their experiences in dealing with distressed assets and restructuring and pseudo bankruptcy. Ethan, I know, has a deep bankruptcy background, so he's actually done the real deal in federal court before, and he's going to talk about its application in cannabis. I'm going to be the moderator. I'm going to try to talk as little as possible to allow the panelists to really converse and try to have a good dialogue about this very tough but very realistic issue. So, as I said, times are tough in cannabis. It's really difficult to be profitable, let alone survive. I just want to ask the panelists off the bat, why do you guys think that's the case at this point in time? Isn't cannabis supposed to be a total and complete gold rush?
So can you guys hear me? It looks like maybe Griffin's audio isn't working. I think it's obviously multifactorial and complex, but it really boils down to this core problem of federal illegality. In my opinion, it's then you have all of these different sort of state markets, states doing different things, oversupply issues, too much state regulation because of federal illegality. It's a hard problem, but if I had to be really pithy about it, I would just say due to the federal situation. I don't know, Hillary, you might even have more complex or comprehensive thoughts on that.
I'm going to go a bit further and also kind of blame the states as laboratories of democracy that are somewhat insensitive to that federal conflict, and overregulation, and in particular local control, has stymied the ability of these businesses to make money and survive, sometimes to even get started. I know where I'm at in California, still, even multiple years after legalization, the overwhelming majority of cities and counties do not allow for commercial cannabis activity within their borders. And that's helped to really undermine the cannabis economy that's legitimate and promote those illegal market actors. And you can't compete against people who don't pay taxes or abide by expensive regulation. So I'd also blame the states in addition to that ubiquitous, troublesome federal conflict. The other thing is, it seems to be in the mature markets, and you guys tell me, obviously, it seems to be a race to the bottom after we have legalization really kind of up and going. And all three of us are in relatively mature markets, maybe Arizona being the youngest for adult use. But I know, Vince, in Oregon, there's a ton of overproduction. And California, I think in some ways is starting to become the same. Even though we have these local control issues, we do have swaths of cities and counties where there's a super high concentration of production. And that's also been problematic for pricing.
Yeah, one of the things that saves Arizona, at least, is that we have a limited number of licenses that are issued for the state. So it's almost like a mini monopoly for the license holders. And they're vertically integrated, so you get essentially 4 licenses in one. I haven't heard about much insolvency in terms of insolvency issues in Arizona. I think that's due in part to the limited number of licenses, unlike California, unlike Washington, and unlike other states where there are no caps on licenses.
I think though the part of the issue is just that there is so much of an oversaturation in the market. Yeah, Arizona and states like that are sort of the exception, although there are lots of folks out there who just ignore the licensing system altogether and continue to do business illegally, which obviously affects the legal market. I think your average consumer doesn't care, doesn't understand what the difference is between a licensed and an unlicensed business, especially, California, where unlicensed businesses are basically given free reign to continue their operations in large part. And, you see illegal storefront dispensaries all over the place. Part of the other issue is that none of the solutions that have been kicked around have really worked. There was an idea in California that eliminating certain taxes, like the cultivation tax, would help. Hasn't really, I mean, it's helped, but it hasn't completely made a dent in the system. So long as you have any licensing requirement or any tax requirement, there are people who are going to participate in the illegal market. And there's been a lot of talk recently about like interstate cannabis compacts between, like Oregon, California, maybe other states. And I think, in principle, it's a good idea, but at the end of the day, you have two markets which are already oversaturated, Oregon and California. And if they're allowed to do business with each other, I think that you're going to have more of the same sort of issues. Just to be clear, I'm not saying it shouldn't happen. It would be nice if there is interstate markets, so like across the United States, globally, even. But I think at first it's going to be very rocky, and it'll really only help states where they're able to offload into other states that don't have mature markets yet. So we're quite a ways away from that actually working out, I think.
Yeah, I appreciate that commentary. I'm sure a lot of people are excited about those interstate cannabis agreements if they will ever happen. The big question, and one I think that we've answered multiple times, it kind of goes without saying because of the federal conflict, but for the benefit of our audience, let's ask it and discuss it again. Is bankruptcy available to cannabis companies? I think surprisingly over the years, at least since 2013, 2012, when Washington and Colorado legalized, there have been kind of interesting carve-out cases where parties have been able to kind of nip at the heels of federal court with bankruptcy. But Ethan, given your bankruptcy background, why don't you start us off with that one?
Sure. I mean, the general rule is a cannabis company cannot file bankruptcy, and that would be a company that possesses, sells, distributes, grows marijuana. And there's a plethora of decisions out there. The first decision came out from the chief judge of the bankruptcy court in Arizona. And the reason behind it is a trustee in a bankruptcy, whether it's Chapter 7, Chapter 11, Chapter 13, cannot take possession because cannabis is still illegal under the Controlled Substances Act. And even if you could get past that initial hurdle for a Chapter 11 to confirm a plan, one of the requirements for the plan is it must comply with all applicable laws. And because you couldn't comply with federal law because it's illegal under the Controlled Substances Act, you would never be able to confirm a plan, even if you could file bankruptcy. Now, there have been some exceptions recognized by courts, but they're not uniform. It's really driven from district to district, state to state. There were two recent decisions in 2022 out of the District of Colorado that essentially allowed a company and an individual to file bankruptcy when they had passive investments in a cannabis company. And that's a departure actually for the District of Colorado that didn't recognize those exceptions before. There's also been exceptions recognized for, say, a landlord who files bankruptcy and its tenant is a cannabis company. Now, those are extremely fact-intensive inquiries, and there's certainly no uniformity there either. And some districts just don't recognize that exception. There's also exceptions for individuals who file Chapter 11. There was a recent decision out of the Northeast where an individual filed for Chapter 13, which is reorganization for an individual with their debt loads have to be below a certain amount. If they're above it, you have to file Chapter 11. In any event, the court in that case allowed the individual to file Chapter 13, even though the individual's income was derived from working at a cannabis company. So there are some exceptions that are out there. They're pretty limited, and the biggest problem of all, obviously, is that a cannabis company can't file, and it's really problematic because oftentimes that's your best way and only way to reorganize a company. All the other options we'll talk about today, it's a receivership, assignment for better benefit of creditors, foreclosure sales, and even negotiated settlements. They just don't. You can't reorganize a company. You can liquidate, and that's what those really are intended for, whether you're selling assets or selling a company, but only bankruptcy can you actually reorganize the company so it comes out stronger than it was before. And, I'm hopeful that at some point it won't be illegal under the Controlled Substances Act, and these cannabis companies can take advantage of the bankruptcy code.
Let's talk about some of those inadequate alternatives to a bankruptcy reorg that are available to the industry. And I get this question all the time, where clients or potential clients want to know, can't I just submit control of my business to a receiver? Isn't that just like bankruptcy, but under state law? And I know enough to be dangerous and say, no, it is wildly different. But why don't we discuss the details, since bankruptcy generally is not available and everything is so fact intensive and specific, of receivership under state law? What is it? Who does what? And why is it different than bankruptcy? And why do so many cannabis companies think that that's a good idea?
Well, I can generally, receivership can either be filed in state or federal court. You would only take advantage of federal court if you were a multi-state operator. There, in most jurisdictions, including Arizona, the power of the receiver is dictated by the order that's entered by the court. There's, in jurisdictions again like Arizona, there's one or two statutes, there's one or two rules of civil procedure, and that's it. And oftentimes you'll see receiverships actions for cannabis companies under one of two scenarios. One is you have a partnership dispute and you have a deadlock, and in Arizona, that's a basis to request the appointment of a receiver. Otherwise, the company just can't operate if people can't make decisions. The other time you often see receiverships is when there's a default on a secured loan. Again, in Arizona, that forms the basis of your ability to request, a receiver. It's a court action. You have to file a complaint. Oftentimes, your sole claim can be just the appointment of a receiver. But again, as we discussed before, a receivership action often leads to either the sale of the company in total or the sale of the assets themselves. But receiverships don't have distribution schemes, or most don't, like the bankruptcy code. Who gets paid from the proceeds of the sale, in what order, and so on and so forth. And receiverships, even though generally they're less expensive than bankruptcy, they're not inexpensive. If you have an operating company that's that has cash flow, the cost of the receivership can be paid through that operating capital. A receiver can also borrow money as well, but oftentimes, if the company is not operating or there's inadequate cash flow, the party that has moved for the appointment of a receiver will be on the hook for all the receivership fees. And they, again, can get expensive because you're paying typically the receiver on an hourly basis. The receiver's entitled to hire professionals, lawyers, CPAs, regulatory people to help the receiver, administer what's the receivership estate. And so, it's an option, obviously, for an insolvent company. It's, again, just not nearly as powerful as a bankruptcy, though. I mean, the bankruptcy code is, it's a long code. There's a lot of statutes, and there are just things you can do in bankruptcy that you just can't do with other forms of insolvency relief.
And my understanding, and you basically already said it, but just to clarify for the audience, with a receivership, you have to have an underlying cause of action, meaning there's a separate fight over, as you said, a defaulted loan or whatever other breached material obligation. And then in that case, do the parties agree to appoint a receiver? And don't they have to engage in motion practice before the judge to even get that appointment?
I can speak, I've had receiverships in several states and in federal court before, but I'm most familiar with Arizona. Typically, there's not a fight because there's either going to be a clear default or the partners, one of the partners will move for the appointment of a receiver. And so oftentimes, and the party moving typically is entitled to appoint the receiver, pick the individual. I've had cases before where there has been motion practice around that. And the court actually looked at the underlying loan documents, which said in the event of a default, the secured party could pick the receiver, and the court deferred to the contractual language. I've had other fights before where people have tried to employ law that just doesn't apply to receiverships, at least in Arizona. And so there can be some motion practice up front. But it's usually fairly limited. Now, as the receivership progresses, certainly could be litigation, there can be motion practice, and it can be very active once you're up and running.
Yeah, I just want to throw one thing in that too, is that their parties could technically appoint a receiver without a court being involved. I've seen it done in at least one case that I can recall where it was non-court appointed, where there was a tri-party agreement with a receiver. The benefit to having a court appointment is there's an order out there that clearly dictates what the receiver's powers and duties are, as opposed to a contract. I think it's pretty rare. Ethan will probably tell you to see something like that, but I've seen it done.
I also want to emphasize to the audience that the outcome of a receivership versus a bankruptcy, very, very different, because the receivership is run for the point of resolving the underlying dispute, whereas the bankruptcy, the point is to reorganize, satisfy all creditors. That's quite a different set of priorities. So let's turn to the regulatory impact of a receivership, since many cannabis companies are turning to that to resolve their bad debt issues and their other financial strappings. What are the cannabis regulatory impacts to the business, to the owners, once something like a receivership is in place? And I'm talking about reporting obligations or any other transparency reporting with the state that might jeopardize the license if not complete. And this is different than receiverships for other standard federally lawful businesses, obviously.
I could try to answer that. So I've actually gone through this in Oregon a couple of times, and a lot of states will have rules, and it's a similarly worded rule in a lot of states. The first version of this I actually saw up in Washington, but the agency regulating cannabis, whether that's the Washington, whatever you call it, Liquor Control Cannabis Board or the Oregon Liquor Cannabis Commission, they'll have something called quote unquote standards for appointing a receiver or a secured creditor or a trustee to run one of these businesses. And what you have to do in that case is go to the regulator and tell them, look, we've got a receiver that wants to sort of take the reins. And it's important for the agencies to know that, because they're going to be doing not just sort of back office spreadsheet stuff, but actually taking possession of inventory, cannabis, and liquidating it and selling it through the vendors and all that kind of stuff. So you kind of have to go through an approval process in a lot of these states with the regulators in order to do that. I remember the first time I did this, I'm actually going to go talk to another group that asked me to talk about this because it was weird and tricky. But we had to kind of go through like several layers of the cannabis agency talking to the Department of Justice to be like, well, how do we do this exactly? And getting sort of permissions and sort of working out issues and then signing agreements with the commission. And I'd like to think that now that the industry has been in dire straits for longer, the upside of that might be that the regulators are starting to understand how to be a little bit more efficient in granting these approvals in a lot of the states and allowing receivers and or trustees and or secured creditors or whoever to run these businesses. So short story is you've got to go to the state, you've got to get permission. If you just go in there and you walk away and you say, okay, so-and-so receiver or XYZ party is now running the business pursuant to either a court order or an agreement we've entered, you could run afoul of your regulatory requirements and could all be for naught. So that's how I'd answer that question.
Vince, what do you see then in a receive or in those type actions when the company is sold? Does that require additional regulatory approvals?
Yeah, it would. I mean, I haven't dealt with one where the company sold, but it would. It would require an additional application where the incoming buyer party would have to apply to be licensed to the regulator and receive a license in its own right. And it would probably have to go through a sort of standard application process, just like with any other purchase and sale agreement outside of the context of a receivership.
Interesting.
And if we can, let's move, I think, to the next alternative to bankruptcy in line, which would be an assignment for the benefit of your creditors. This one is up there, at least for me personally, with the UCC defaults, where essentially we have your valuable assets going out to a third party. What are we talking about? The cannabis license, the business interests of the cannabis business itself, the equity, and the inventory. If I'm a creditor, can I just take a buttload of cannabis, liquidate it, and call it a day after it's been assigned to me by a licensee? I think that's what people probably want to know. And the reason why I bring this up in that context is because we often get, I wouldn't say vulture investors, I'm not going to go that far, but we get third parties where they've got whatever financial instrument, there's been a default, maybe there's not a security interest, but there's an assignment. And they want to know, can I take this cannabis-oriented asset and just run with it to make myself whole again? And I think that's a more complicated question than it sounds like because of the federal illegality, because of all the hoops through which you must jump with the state. So let's just take it from the top. What is an assignment for the benefit of creditors?
I mean, we call them ABCs. Arizona has an ABC statute. In my 24 years of practicing insolvency, I've never seen an ABC action or in Arizona. However, California is very active with ABCs when it comes to insolvency. An ABC is a contract by which an economically troubled company, which is known as the assignor, transfers legal and equitable title as well as custody and control of its assets and property to an independent third party, which is the assignee. Those assets are then held in trust. The assignee is then required to apply the proceeds, the sale of the property, to the assignor's creditors. So it's an agreement among the parties. It doesn't involve a court action. When it comes to kind of the basics, first you need the assignment agreement has to be executed. And then the assignor has to turn over the assets to the assignee that are being assigned. The assignor then has to give the assignee a certified list of all creditors, including their names and the amounts owed. The assignee then has to provide notice to the creditor body of, what's happening, what kind of distributions may come out of the ABC, and some other information. Then the creditors, when they get notice, they have 150 to 180 days to file a claim, which is, hey, this is what I'm owed, and this is why I'm owed the money. And there's usually standard claim forms. It's really akin, you see this in bankruptcy as well, where you have to file a proof of claim in a bankruptcy to assert what you're owed in that bankruptcy. After the claims come back in, then the assignee again has to reconcile those claims, can object to claims. Again, a lot like a bankruptcy concept. After the liquidation, then the assignee has to determine distributions, who gets paid in what order, and so on and so forth. Now, in certain states, there are statutory schemes that outline, who gets paid first, like the professionals, like the assignee himself and any professionals he hires, and then down the line from there. And then some states will also adopt the bankruptcy code in terms of the distribution scheme. The assignee will then look for any new UCC liens that are out there to make sure there are no other lien holders that purport to have an interest in the assets being sold. Then, the assignee, again, secures the assets, and then sells them for cash, and then the cash gets distributed. Now, the assignee can continue to operate the business, but to maintain going concern value. But that's I think less typical than the company itself, being non-operational. It normally takes about 12 months to conclude an ABC, and that's kind of like the basic process of how an ABC works.
Yeah, I don't think I've ever seen an ABC in cannabis. Maybe the three of you have. I never have. And there's probably good reason for that, because I don't really see an escrow agent taking into its possession federally legal contraband or cash. Not to say that it couldn't happen if state laws permit it. In California, we do have a statute that says commercial contracts for commercial cannabis activity are lawful. They can be invalidated for illegality. So it could happen. But then we have the regulatory underpinnings back to Vincent Griffen. So if you saw an ABC, knowing that escrow has to take possession, and then we've got distribution to assignees, I assume there's some reporting that would have to go down with the state, right?
You're just not going to see these actions, I don't think. Here's why. Licenses themselves are generally not transferable. You can't really take a security interest in a license for the same reason. I mean, some states might allow it, but like California, it's just not going to happen. So that's one of the big assets. Cannabis itself, if I'm like a lender or a bank or something and I have a security interest in some of the assets of the business, I can't go take like 2,000 pounds of cannabis and try to sell it myself. I don't have the licenses to do that. And there's some workarounds that some businesses put in their agreements, but I mean, a lot of the lenders aren't even going to be interested in that. The third bucket of assets that a normal company would have, or a cannabis company, is like machinery, inventory, non-cannabis inventory, if any, other personal property. The problem is that with cannabis companies, since they end up not having a lot of money and upfront investment is so high, they either won't own a lot of those assets, they'll have equipment leases, for example, or they will be secured in favor of some kind of lender. Like if some lender will have an all assets loan, in which case I don't think it's going to be very easy to do an ABC when those assets, someone else has an ownership interest in them already, unless the ABC is for the benefit of that creditor. And then on the regulatory side, I mean, I guess it just depends on the jurisdiction. I think if, like, let's say machinery or something is taken and assigned for the benefit of a creditor, I'm not sure that in and of itself would implicate anything in California. But again, it's something that I really don't see as happening very often. And then, another issue, which I'm sure we're going to come back to later, is that doing one of these, either a receivership or an ABC, is going to just have a domino effect at the company level in terms of like lease agreements, just general agreements. So that's something we'll probably talk about in a little bit. But I don't think we're likely to see many, if not any of those in this state at least.
Yeah, that's tough. I know, at least speaking for California and in the state of Washington, you'd have to have a license, a cannabis license, for that particular ability to sell at retail, because we can't go back down the supply chain, right, back to the wholesalers. It has to go out to the public, meaning at the end of the day, the regulatory brain damage and the cost of even making those assets liquid would probably not be worth it to pretty much anyone. So let's move on to state liens, state law liens, commonly, obviously, from the Uniform Commercial Code. These are typically referred to as UCC1s, or security interests. And we do see a lot of security interests flying around. We basically have for years. And just like all of these alternatives to bankruptcy, because it's cannabis, because of the state, the patchwork quilt of regulation, state control, and the federal illegality, this is another somewhat inadequate alternative. But I do think that these UCC security interests under state law fare better than probably ABCs for a number of reasons. And there are procedures and protocols, sometimes expressly within the cannabis regulations, about how to do this. But let's talk about the UCC for our friends in the audience that may not know or need a refresher. What's a security interest? How do they work? And how do they typically work in cannabis? What are we seeing in the field these days?
I mean, I could talk about just state law foreclosures in general, and then other people fill in some of the color for cannabis. I mean, the UCC stands for the Uniform Commercial Code. It's a comprehensive set of laws governing all commercial transactions in the United States. The UCC has been called the backbone of American commerce. Just as an aside, there's also a foreclosure process, which is separate than the UCC for real property. And that's driven by statute as well. And in both instances, whether you're dealing with personal property or real property, it's very formulaic. I mean, it's not under either scenario, real or personal, it's not a complicated process. When it comes to personal property, though, again, very formulaic. The party who has a security interest in an asset can notice a UCC sale. And like at ABC, there's no court involvement. This is all done by the secured lender. And a secured lender is someone who's taken a security interest in a particular piece of collateral. And you see that under loan agreements. Where you'll end up, as Hillary said, there'll be a UCC1 filing at the Secretary of State level in a state. That way people can search and see what liens are out there that have attached to any particular set of collateral. It's the first thing you have to do for an Article 9 sale is run a UCC search. You need to know who all the interested parties are, including, for example, a guarantor. A guarantor would be an interested party. Any junior lien holders would be an interested party. The second thing you do then is you have to provide notice to all these parties that there's a foreclosure sale coming. And in that notice, you have to describe the collateral that's being sold. And you also have to tell the parties, when is the foreclosure sale scheduled for? You can continue foreclosure sales once you've noticed them. That's not an issue. And then you go to the foreclosure sale and the date notice, unless you're extending it. And as a secured lender, you can then credit bid up to the amount of what you're owed. So if you're owed $1 million, you can go in and credit bid up to $1 million. Now, most secured lenders will only bid or start their bidding at what they believe the value of the asset is. And they do that because if no one overbids them, then they can bring a deficiency action where they then sue the borrower for the difference between what they're owed and the value of their collateral. In most jurisdictions, too, you have a statutory period of time to bring that deficiency action. And if you don't, you've now waived that action forever. And that's that. And then ultimately, at the end, the successful bidder gets a bill of sale, and the bill of sale transfers legal title. It describes what's being sold. And that way, the buyer has evidence, a legal document that says, hey, I'm now the new owner of these assets. When you have a foreclosure sale, and you're the senior secured lender, if there are junior lenders under you, you can wipe out those liens. So the buyer takes it free and clear of those junior liens, unless there's enough equity to start paying junior lien holders. And that does happen from time to time. One thing you can't wipe out, at least in most jurisdictions, the ones I'm familiar with, are recorded tax liens. Recorded tax liens typically run with the property, certainly for real property, and even a recorded lien on personal property, I believe, can also run with that asset. So again, you want to make sure there's no tax liens out there. And sometimes a secured lender has to pay off those liens if they want to take the asset or sell the asset. And they do that under a future advance clause under a loan document where they can advance money and then it's secured by the same promissory note and UCC1 filing or your deed of trust, whatever the case may be. The nice thing about foreclosure sales too is, like I said, they're fast and they're inexpensive. They just don't take much time. They don't take a lot of legal, firepower to do it. And again, in every jurisdiction I'm aware of, it's very, very formulaic. It tells you exactly what you'd have to do. It tells you the time frames in which you have to do it. So it's a pretty easy process.
Yeah, I'm going to translate that in 30 seconds or less, basically. So usually you've got a lender, or in an M&A deal, a seller carried financing of the purchase price, right? So you've extended some form of legal value, and in return, to ensure you get paid, you take a security interest in some valuable collateral of the other side. If they default, they breach, they don't pay up, they miss a deadline, whatever, then you can go ahead and, in most scenarios, depending on the type of collateral, and there are multiple different types, take possession or custody of it and then liquidate it up to the money that you allocated. And not more than that. There's a common misconception that somehow you can keep this collateral in the cannabis industry. You cannot do that. The whole point is to sell it on the courthouse steps, as we say, and get your money back, and then ultimately pay junior lien holders unless they're wiped out. And then, as Ethan mentioned, you have deficiency issues where you can go and sue for the value owed because the collateral wasn't as valuable as you maybe thought it was. That's a pretty big oversimplification of that process. Now, for Griffen and Vince, when we have UCC interests, whether it's on the business interests, shares, or membership interests of the company, the license itself, if that's permissible, if the license is transferable, or inventory or cash, what have you seen in the field as far as reporting requirements go? Because even though Ethan is saying generally these are fast, they're painless, the whole point is to bypass the court and the government, make it automatic. That's not going to be the case with cannabis UCC secured interests.
So you're talking about reporting requirements on the front end to regulators, like say when a business,
Not even
licensed
that.
businesses. Okay.
I'm talking about the ability to actually foreclose, right? The crap has already hit the fan. Your borrower in the lending capacity is in default.
Yeah.
How do you as the lender go forward to foreclose, given the fact that only certain people can own these things, only certain people are on record with the state, there may be background checks involved to take possession. Basically, how painful is it when we're talking about secured interests with cannabis?
Okay, so I think that's a super fact dependent question, and it's going to depend on the state and the nature of the security interest being taken. For instance, if it's an interest on a minor shareholder's shares in a cannabis business and they fall below some de minimis reporting and pre-clearance threshold, then it's not so big a deal. I mean, that transaction may have to be reported or it may not at all, and it may have to be pre-cleared and it may not at all. It just sort of depends on the level of the whatever the asset is being collateralized, shares, what have you. And it sort of depends on the state's rules at the time and the state's guidance at the time with respect to those rules. And that stuff evolves over time. So I know people are listening from all over. And I hate when lawyers say things like, well, it depends. But it really does depend in this case. It depends on the type of transaction and where you're at. That's where I leave it.
I'll put a little bit of a final point on that too. In California, there's two different things that I think of, two buckets that I think of as being more complicated than just, your average asset like a machine or a car, intellectual property, or even real estate. The first is the licenses in and of themselves. They're not transferable under state law, period, end of story. And so what we see some lenders do, I mean, yeah, some people will take a security interest in all assets of the company, which would include, by definition, a license, but they just, a lender client will need to understand that that's not something they're going to get. What people often do as an alternative to that is to take a stock pledge in the company that has the license. So, in a lot of loan transactions, the loan might not be provided to the operating company itself or to like the parent of it or an affiliate. And so they'll take the owner of the company with the license will pledge their stock as security in case the borrower defaults. That way, you're not taking the license, you're taking the company, and you're probably going to need to go through change of ownership process. You will need to go through change of ownership protocols to do that. There's an established way to do that at the state level, and each locality in the state of California is going to be different. But something to think about for a lender, like, do you actually want to operate a cannabis business? Do you know how to do it? If the borrower is unable to pay you, do you want to go in there and take over a company and inherit all of its, tax and other liabilities? And like to Ethan's point, if a company is not paying its creditors, it's probably not paying the state taxes either. There's probably going to be tax liens out there. The other bucket is the cannabis assets, right? So the inventory, the work in process inventory, plants, all that stuff. And if you have an all assets lien rather, that's all included in it. And so from a lender's point of view, like we've mentioned this a few times, you can't just go and sell this off, right? Easily. You need a license to do that. One of the workarounds I've seen some lenders ask for in contracts is to say, okay, if there's a default, you, the borrower, will find a distributor to come basically take this away and sell it and give us the proceeds. It's kind of clunky because you have to assume that the borrower who defaulted is going to cooperate with you, which they might not want to do, especially if it's an adversarial situation or if the default is less than clear. But it, is one of the few alternatives. I mean, also, getting a receiver appointed to come in there and run the business and sell the assets off in a productive way is an option. But that circles back to some of the issues we've talked about before.
I will say that we do have clients that if they are going to lend in the space, they're only looking for a particular kind of collateral, and they don't want to mess with anything that's cannabis oriented for these very reasons. One, just by way of example, is a fund, they're totally dedicated to real estate, and they will only lend to operators that own their real estate so that they can take a security interest in the land, which is called a deed of trust. If you can get that as collateral, that's going to make your life a lot easier, because in all of these states, there's no reporting requirement if the title to the land changes hands, because it's not considered part of the cannabis business outside of the permitted premises where the use is taking place. So that can kind of be a nice alternative too. We did get a question. It's an interesting question, and I'm going to rephrase it. Is a cannabis company's lease interest not subject to a pledge? Is that something that legally you wouldn't see pledged by a cannabis company, the interest in the lease? Why or why not?
Would they be allowed to do that? I'm just thinking you'd have to look at the lease itself, and often leases prohibit assignments, right? I mean, the landlord will say the lease is not assignable, or it's only assignable subject to landlord approval. So I'm not sure how a tenant could go ahead and pledge its interest in a lease. I don't know if anybody else has thoughts on that, but that's the very first thing that came to my head.
No, I don't. I mean, it just doesn't. I don't think that, from a tenant's point of view, I don't think it makes a lot of sense, because you'd have to transfer the property and the new person wouldn't have a license. If they're asking about, the rents that are due under the lease, if the landlord's borrowing money, sure, I mean, I've seen that kind of thing happen. The income's derived under a contract. The landlord can assign that as part of, a finance agreement of some kind. I mean, something we've seen. But from a tenant's point of view, I mean, what they're getting under the lease is the right to occupy property. And to Vince's point, most landlords aren't just going to want some random person coming in there without their consent.
That's one of the unfortunate parts about not being able to file bankruptcy, because in bankruptcy, a debtor can assume and then assign leases. Now, there's requirements. You have to cure defaults. There has to be adequate assurance of future performance. But there are some companies, large retail companies. I had a case years ago in Florida. It was 500 Waffle Houses, and they filed solely to renegotiate all their leases with the landlords. But again, it's something that's just not, without bankruptcy, you don't have those options. I wanted to mention one other thing before I forgot. There is a last option when it comes to insolvency, and that's a negotiated settlement. And Vince and I had a case a year and a half ago for a hemp company. And we looked at all the various options. We looked at bankruptcy, we looked at foreclosures, and for a variety of reasons, we couldn't make it work. But we ended up negotiating with the senior secured lender, who agreed to take a discount on the debt that was owed, because our client wanted to sell its assets to another company. And then there was also an SBA lien that was out there. And you can't wipe out an SBA lien pursuant to a foreclosure sale, but we came to learn that the SBA will allow the assignment to a new company of that loan. There's a process behind it, but it does exist. So in any event, I just wanted to raise that as an additional option, especially for cannabis, given some of these regulatory issues. The last option is always, can you negotiate with your creditors to try to make things work, whether it's a sale to another company or whether you're going to continue to operate. There are times that you can reach a settlement.
And to just kind of emphasize one thing about what Ethan just said, I remember which one you're talking about, Ethan, and that was a hemp company. And the hemp company analysis is wildly different than what we've been talking about so far with marijuana cannabis, right? I mean, hemp is not federally illegal, so a hemp business has a lot of options than a cannabis doesn't have with respect to everything we've been talking about. Just want to make that clear.
Mm-hmm.
Yeah, and ladies and gents, we are not answering hemp insolvency questions today. That is well beyond the scope of this presentation. Get that out there. But before we leave these kind of shoddy alternatives to bankruptcy, in my opinion, we did get some good audience questions that I think are worth answering. So the first one is actually very relevant. Does the receiver itself need to be cleared by the state licensing agencies and or have a license itself? Fair question.
So I know some states like Washington were sort of innovative in that they went through and sort of pre-vetted and pre-approved and appointed receivers in the states who are eligible to work with these businesses. And that's kind of nice because the business can just go and have assurance that whatever receiver they're going to work with already has been kind of through their paces with the LCB. Other states, not so much. In Oregon, where I am, there is no such list. And I don't know if there's ever been talks of such a list, but basically you have to just go through this protocol where you sort of apply to have a receiver run their business. And there's no knowledge by the administrators or from the administrative point of view as to who this person is. I suppose they just sort of trust that this person knows what they're doing or is a receiver, but that's kind of it. So again, each state's different.
Well said. Another question, kind of a curious one. In a federal bankruptcy, if the debtor is non-plant touching, we see them all the time, right? They do packaging and labeling, bottles, IP, management companies, real estate. Is it permissible under federal law for the bankruptcy to move forward if one of the creditors is a state licensed cannabis company? Anybody with an opinion? It's okay if you don't know and need to do some further analysis.
Yeah, I don't think that would be.
Ethan.
I don't think that would be an issue. I mean, you're owed money, right? And as a creditor, you're not going to have a trustee appointed over you to take possession of what you own. You're the one who's owed something. So I don't think in that scenario you would have an issue being, a creditor in bankruptcy. It's really the debtor that runs into issues, not the creditors.
And then we did get a specific California question, which I'm going to direct at Griffen. It was, in California, doesn't the Department of Cannabis Control require notice if a business becomes insolvent regardless? And the follow-up comment was, they're asking because many of them are in fact insolvent, which I do believe.
I don't think insolvency alone triggers notice requirements. I don't think so. I mean, there's a notice requirement if a receiver is appointed or if there's like a death or disability and you need to appoint a successor in interest, but I don't think just running out of money requires notice. I would have to look into that, but I mean, the commenter is right. There's a lot of businesses out there that are not able to pay their bills. I mean, that's why you see CDTFA, which is the tax agency here, has like literally $250 million in unpaid taxes that it's chasing down. With tax liens left and right. So I'm not sure that just the insolvency requires a notice. I'd have to look into that, but I know that the receiver will have notice, but it doesn't sound like it's as involved as some of the other states that were mentioned. I also, just not to speak out of order, but I see a comment coming into something I mentioned, which was the stock pledge. It says to do a stock pledge, wouldn't you have to have a stockholder sign documents in order to take that stock? I mean, there's two sort of signing points that I can think of. The first would be the actual pledge agreement. Like a company can't pledge its own stock. The stockholder would need to sign that agreement because it's an asset of the stockholder. And that is often something that we see in the context of loans, right? Like the owners of the company want the company to get money, so they pledge their stock up front. In that agreement, they covenant often to sign documents like submissions to the DCC to change ownership in the event of a default. And in a good stock pledge agreement, they'll even agree that if they refuse to sign, there's an appointment of the lender as an attorney in fact to sign on their behalf. And I've not seen it come to that before, where that has to happen. But I mean, yeah, it could very well end up in litigation. We actually saw a while ago an instance when somebody left the company on bad terms and wouldn't agree to sign documents that said basically I'm out, which is a requirement under California law. And we were able to work with the regulator and provide documentation to show, hey, in fact, this person is, not an owner anymore, and it was okay. But again, super fact specific. I think that if you have a stock pledge agreement, it's a good call to have attorney in fact designations and like a very strict requirement that the person comply and sign things if the company defaults.
Okay, so moving on from these alternatives, we got a lot of questions about what M&A is looking like right now in the industry. I know, in my opinion, most of it has come to a screeching halt because there's just not enough money in the space to support those transactions, and outsiders looking in are waiting and watching. I think there's probably more vulture investing, buying up bad debt essentially and restructuring from within as they can, more than there's M&A. But what are you guys seeing out there as far as M&A trends?
Yeah, I agree. A lot of fire sale stuff or attempted fire sale stuff, people getting pennies on the dollar for anything, if at all, people just throwing up their hands and walking away irresponsibly or otherwise. But I feel like, I've heard VC people say, I wouldn't touch Oregon or California with a 10-foot pole right now. And it's how people feel. I think there's a little more concentration on newer states coming online, perhaps, but things have definitely cooled. Debt's a little more expensive than it was a few years ago. There's not all this COVID money flying around. A lot of the markets have just sort of bust in terms of like they've hit consumer side demand ceilings and now they're kind of on a tail with respect to sales. So it's dried up a lot. And if you're getting into an M&A deal and you're a buyer, potential buyer, or on that side of the equation, you've really got to think hard about some of the things we've been talking about today, because a lot of these businesses are going to have warts all over them with respect to finance, essentially, and sometimes that leads to compliance issues. So, and demand to see everything you can see and get your hands on, and then be prepared to move fast, I would say.
Yeah, I mean, Vince is right. We used to do lots of M&A a couple of years ago, even last year, and I feel like it's gotten much smaller. I mean, California's always been a terrible state for M&A in my view, because A, it's expensive, and B, the way that the system is set up, you can't just do like an asset purchase where you could do that in Oregon. I've worked with Vince on a lot of those deals in Oregon. You have to buy the business, and a lot of these businesses have these massive tax liabilities. They're getting sued by employees. You name it. Not a good place to have to do M&A. But even in Oregon, like we're seeing we could do license sales up there effectively, and we're seeing licenses sell for like, the price of a used Toyota. It's not what it was a few years ago. And a lot of businesses that were buying things up left and right are now not in great condition, especially if there was seller financing, and evaluating the sale of the business is tough. And we're seeing businesses dump assets. We're seeing businesses just abandon licenses. Manufacturing distribution licenses in California, we've seen people drop those off a lot. Since like if you're not very good at those things, it can be sort of a drag on revenue. But yeah, M&A is certainly not what it was a couple of years ago.
And in the last 5 or 6 minutes or so, let's discuss due diligence, because somebody somewhere is going to take advantage of this situation, whether it's mass consolidation with MSOs that somehow are able to rally the cash to do it, or other enterprising folks that see a great deal in what Vince is calling these fire sales. What kind of diligence specifically should be done for these companies? You can talk about the general or anything that's really specific when a company hits the skids in its life cycle like this.
I want to answer this because this is something that I've been working on quite a bit. And it's something that people very frequently overlook and should not overlook. the first thing I like to do is to get under the hood and look at all of the business's contracts. Because if you look at any lease, if you look at any loan agreement, even just general commercial contracts, there's a host of insolvency defaults. So, I mean, you might have like a distribution agreement that says that it's a default if one of the parties, becomes insolvent, which is sort of a broad term, but like oftentimes they're very specific. Like they make an assignment for the benefit of creditors, a receiver is appointed, they consent to the appointment of a receiver. It's usually like a long list of things. And so I think of these as like default traps. If a business does a receivership, suddenly they're in default of all of their leases, all of their loan agreements, a number of their different contracts, and they need to understand that stuff like up front. Because they're going to need to be in a position where they'll have to negotiate with their landlords, their lenders, et cetera, right? And I think, that's just one of the first things that needs to be done, because failing to do that, you could be walking the business into really some serious pitfalls. So that in and of itself is going to limit a lot of the types of relief that businesses can seek in reorganizations, like definitionally. And if you're a business that is thinking about some of this stuff, I urge people to engage a lawyer who understands this, because, like I said, just not doing it is not an option.
The other thing that people should look at just real quick is anything that's publicly available. Like Ethan was talking about UCCs, you can do a free lien search most of the time, or a cheap asset type search. And you can also do inquiries with respect to public records and the business's license itself to see if there are any proposed notices of license cancellations or things that would make a sale of the license interest non-viable in the first place, or the business non-viable. So there's a lot of stuff you could do. You could search Secretary of State website for trademark registrations, etc. Don't bypass all of the free information that's out there when conducting your diligence.
Yeah, I agree with Vince. I mean, you can also fairly inexpensively hire third-party companies to run litigation searches, tax lien searches. I mean, you can do some of that on your own, but you can get comprehensive searches pretty inexpensively, in the grand scheme of things.
We did get a question in the last 3 minutes. I love this question because it's kind of stories from the front, and it gives us the opportunity to talk about what we're working on without revealing names. We have a comment and a question. I'm interested in California distressed deals. Totally fine with hairy deals. Would love to see some of the deals you're discussing. I can say right now, we are in a post-close phase where we represent the seller, which is a retailer in California. And one of the things that they are continually having to deal with post-closing is a very bad tax situation with the CDTFA. This is like 80% of the companies in California at this point, and there's a huge misconception that you can somehow negotiate like the devil in a Faustian deal with the California Department of Tax and Fee Administration. Let me correct that sense. That is not possible because just like secured interests, it's very formulaic in how you deal with CDTFA. There is a template that they go through and they do not deviate. And any lip service about being able to get funds to pay off debt or restructuring the debt, they will absolutely ignore, and they are entitled to ignore it with the authority that they have under statute. So that would be a hairy deal that you will see in California, that there are these massive tax liabilities, and that's just with the state. I'm not even talking about 280E. And I wouldn't necessarily say that that was a distressed deal where everyone was running for the exits, but it was quickly kind of coming up on that. And one of these post-closing issues that we're still having to revisit again and again and again is the tax liability with CDTFA, because until it's paid off, they keep knocking at the door and wanting to review financing and make sure that no money is hidden. And the new buyer not loving that piece of it. So that's one thing that we're seeing. Anything else, guys?
Yeah, a lot of the tax stuff is coming up.
Okay.
Yeah.
Well, yeah, I know the tax man cometh really bad in California now. But I want to thank everybody for their attendance at this webinar. We always appreciate everybody showing up and listening. For the majority of the time, there were more than 200 of you tuning in. We will republish this webinar on the Canna Law blog, and depending on the follow-up questions we get, we may even do a series of blog posts or a blog post just to address those particular questions. So thanks again for the time and attention. We appreciate it, and we'll see you on the next one. Thanks.
Thanks, everyone.